Law and jurisdiction. This podcast considers the question of how one determines which law applies to a contract and which jurisdiction can hear a case brought under a contract. In that sense, this is perhaps one of the more European-specific of the recordings, in that it attempts to deal with a situation in which the parties to a contract are spread across different EU member states. However, hopefully the principles will be of interest even to those of you who are not based in Europe or not thinking about contracts with a European element. It is possible, perhaps surprisingly, to separate the law which a court must apply from the jurisdiction of the court itself. As such, you could end up with a situation in which you picked a particular jurisdiction, for example a jurisdiction close to you and the other party to a contract, but pick an applicable law which you consider to be more appropriate. More often than not, at least in my experience, the law and the jurisdiction will be the same. In this podcast, I will talk first about the rules of applicable jurisdiction, which countries' courts have the power to hear a dispute, and then about applicable law, which is, of course, particularly relevant in terms of identifying a party's obligations and rights under a contract. The mechanism for determining the jurisdiction applying to civil and commercial matters within the EU is set out in Council Regulation 44/2001, the Brussels Regulation. There are two aspects to this. The first is that the applicable jurisdiction is that which is agreed between the parties. So as a starting point, check whether there is a jurisdiction clause in the contract. If there is not, you'll need to proceed to the rules within the Brussels Regulation as to where there is no agreement. As I say, the Brussels Regulation 44/2001 sets out the framework here. The default position in the absence of agreement is that a person domiciled in a member state is to be sued in the courts of that member state, i.e. sued in their home courts. And this default position is subject to a number of exceptions. In matters relating to contract, particularly pertinent here, the applicable jurisdiction is that of the place of performance of the obligation in question. Unless the parties have agreed otherwise, in the case of sale of goods, this is the place where the goods were delivered, or should have been delivered, and in the case of services, the place where the services were or should have been performed. Second, there's an exception that relates to consumers. Consumers are afforded greater protection than general business customers, and where services are supplied in the course of trade to a consumer, the applicable jurisdiction is the country where the consumer has their domicile, provided that the supplier either pursues commercial or professional activities there or directs activities to that country. What does it mean to direct activities to that country? The Court of Justice of the European Union has ruled on this in the case of Alpenhof, which dealt with a German citizen who stayed in a hotel in Austria. He did not find the hotel to his liking and left without paying his bill. The hotel sued him in Austria, and he claimed that as a German citizen buying as a consumer, he should be sued in Germany, and that the hotel directed its activities to him in Germany. At paragraph 83 of the judgment, the court held that certain aspects of the hotel's behaviour would indeed count as directing. I'm going to work through these with you, and I think the sense that you'll take away is that these are very broad indeed. The court held that the aspects of behaviour that would count as directing include the international nature of the activity at issue, such as certain tourist activities, mention of telephone numbers with an international dialing code, use of a top-level domain other than that of a member state in which the trader is established, for example in the case .de, or use of a neutral top-level domain such as .com or .eu. The description of itineraries from one or more other member states to the place where the service is provided, describing travel for example, or the mention of an international clientele composed of customers domiciled in various member states, in particular by presentation of accounts written by such customers. these are really quite broad. In particular, they seem to say that any site using a .com or .eu top-level domain for its website is directing its activities to any country in Europe. This approach was sustained in the UK in the Omnibil case, and although this is a copyright case rather than a contract one, paragraph 23 of the judgment shows how the court followed the approach of Alpenhof, that if you put a phone number on the site and you use an international dialing code, it means that generally you are targeting your site to non-residents, since if it were just targeted at a domestic audience, no such code would be needed. In terms of applicable law, this relates to the law which the court would apply in attempting to interpret the rights and obligations of the contract. As with jurisdiction, the EU law on applicable law is set out by way of a regulation, Regulation 593 of 2008, on the law applicable to contractual obligations. The regulation splits the determination of applicable law into three cases: where there is agreement, where there is no agreement and the contract is between businesses, and where there is no agreement and the contract is between a business and a consumer. The basic principle of these regulations is that of choice by the parties to the contract, a choice which can be made and modified by agreement at any time. Where a person can demonstrate that he has agreed with the other party the applicable law, that is the law which applies to the contract. As such, a pragmatic seller will ensure that his or her contract contains an appropriate choice of law clause. The exception for consumers is that where one of the parties is a consumer and the other a professional, an agreement as to applicable law does not override protections afforded to the consumer by the laws of his domicile, from which derogation is not permitted. For example, a consumer domiciled in the United Kingdom would not lose his ability to rely on an implied warranty that goods will be of satisfactory quality, as against a business seller in another member state, even if he has purportedly agreed to lose such rights. In the case of a contract where there is no agreement on applicable law between businesses, the regulations acknowledge that not every contract will have a clear choice of law clause, and they provide what's really quite a confusing series of options to deal with this. The general position where there is no choice is that the deemed applicable law is the law of the country where the seller or the service provider has their habitual residence, a notion which is different to that of domicile. However, where all the circumstances of the case make it clear that the contract is manifestly more connected with another country, the laws of that other country apply. In a similar vein, if a court is unable to reach a decision as to applicable law based on either of the approaches above, the applicable law is that of the country to which the contract is more closely connected, again necessitating a comparative exercise. Where there is an agreement between a business and a consumer, the same exception applies in respect of applicable law as it does with applicable jurisdiction, but with one potentially significant difference. The habitual residence of the consumer is the one which is most relevant. If supplier pursues commercial or professional activities there, or directs activities to that country, but it relates to habitual residence rather than to domicile. The most practical, sensible approach, of course, would be to make sure that, in the context of a documented agreement, both law and jurisdiction are spelt clearly out in the contract, so there is no room for ambiguity. Staying silent on matters of law and jurisdiction, other perhaps than in the context of a contract which can only ever be very local in nature, is risky. And since it can be remedied by just one additional, probably entirely uncontroversial clause, I would not leave it to chance. I have included in the materials a copy of my article, Law, Jurisdiction and the Digital Nomad, which was published in Computer Law Review International, which takes some of these principles and explores them in more detail in the context of service providers who provide services over the internet on a very much itinerant basis, which I think you may find interesting and useful.